Fred Korematsu was a man whom you would never have expected to skyrocket to fame. He was just a humble man, he was a worker, he was a welder, and his turned out to be one of the three famous test cases of the evacuation and the internment. The other two cases were those of Gordon Hirabayashi and Minoru Yasui, who were educated men. One of them ultimately became a professor, the other a lawyer, and they consciously objected to the internment and deliberately challenged the orders of curfew, evacuation, and internment. Korematsu, on the other hand, was a guy who simply felt in his gut that it was wrong and that he didn't want to go. And so what he did is he more or less went into hiding. He had light plastic surgery and he fixed up his draft card because really all he wanted to do was to stay with his Caucasian fiancée. And of course, as we know, he was ultimately apprehended on a tip. So it's interesting that Korematsu's case, which was not a deliberate challenge to the orders of evacuation and internment, was ultimately the one that became the most famous case. In Korematsu, the case of the Supreme Court case of 1944, the justices in effect upheld the constitutionality of the internment.
To believe on the Constitution and also anything that's within rights. If you think you're right and go along with it and to fight it, you know, to not give in. Like I did, I knew, you know, hey, it's against the Constitution what they're doing, and you know, even though, you know, like in here, you know, like I say, hey, what we're doing here is wrong, and I don't hear anything about the rest of them. So maybe they're right, you know, and I'm wrong, but I'm going to find out. So stick to your guns.
And it wasn't until the 1980s that Korematsu's case, along with Hirabayashi's and Yasui's, were reversed. But the case, Korematsu's case, didn't go all the way to the Supreme Court. And so the constitutionality of the internment has never really been challenged in the Supreme Court. In other words, the Korematsu decision remains on the books of the Supreme Court. And so Korematsu has become a case of enormous interest to lawyers, and it's a case that all law students study. Robert Jackson eloquently points out at the beginning of his dissenting opinion that Korematsu was a citizen of the United States. And in effect, Robert Jackson goes on to say, not in these words, his only crime was his face, which he tried to alter. His only crime was his ethnicity. And Jackson found that a tremendous outrage. And I personally think that Jackson's dissent of the three dissenters in that case was perhaps the most eloquent, certainly rivals Murphy's. Robert Jackson's words echo today, and they've been quoted many, many times. He said that if the Supreme Court were to decide against Korematsu, they would be giving the country, in essence, a loaded weapon that could be used against anyone. And that's what people fear. Japanese Americans fear it especially, but anyone who's interested in civil liberties fears it. And it's an especially dire warning today. So we're really indebted to Jackson for his courageous dissent and for his extremely important words that I take as cautionary words. It was Roberts, Murphy, and Jackson. Roberts' decision is And dissent, you probably read it in your material, right, Greg? Robert's dissent is not terribly interesting to the layperson, I would say. Do you think I'm right about that? I mean, he gets into questions of constitutionality, but he doesn't come off the way Jackson does, as really outraged by it and really a principled person. I'm sure he was principled, but he's more academic. And Jackson is really passionate about it.